I will be talking about the legal basis of participation of welfare associations in political decision-making processes here in Germany. And at the beginning, I would like to point out why I am talking about this subject. I am a lawyer, and after I passed my law degree, I decided not to work in a classical field of law, but to work in social interest organizations in Berlin. I've been doing this for the past 20 years and came to TH Köln in 2020. So my perspective on the subject shall be a very legal one. I will talk about the legal basis, but against the background of my practical experience. To the outline, I would like to put a focus first on legislation and the role of welfare organizations within this process. Afterwards, I would like to illuminate the rights in political decision-making processes, especially of welfare organizations. I want to put the question whether there are any rights that social welfare organizations have. After that, I would like to put the emphasis on the legal instruments of participating in political decision-making process. And finally, I would like to look just briefly at the legal and practical boundaries that welfare organizations are put on in participating in political decision-making processes. And finally, I would like to draw a short conclusion on the points that I will present to you now. Well, first of all, what is the role of welfare organizations and how functions legislation within Germany? I would like to present to you first of all the hierarchy of law, and surely many of you might know this already, but my aim is not only to recall the different levels of law within the German legal system, but also to clarify and to limit the subject of my presentation. So, on top of our hierarchy is EU law, and I want to point out right at the beginning that I'm not talking about participation in decision-making processes on EU level, because this follows its own rules on EU level, and this is surely could be subject to a panel itself. I want to talk about the national level, and there are two levels. First of all, the Constitution of the Federal Republic of Germany, which is called in German Grundgesetz, and I will use the word Grundgesetz and not the English translation basic law, but Grundgesetz, and of course federal law. And I would like to start with a principle, with quite a very important principle within our democratic system, which is the people's sovereignty. Article 20, paragraph 2 Grundgesetz has the following wording: all state authority is derived from people. It shall be exercised by people through votes and elections and through specific legislative, executive and judicial bodies. So what's the meaning? What's the meaning of this sentence? I think, as to our subject now, there are two important aspects that should be pointed out right at the beginning. First of all, this principle of people's sovereignty has the content that all actions of the three branches of power, executive, legislature, and judiciary, need a legitimacy by German people. This is the first and very important aspect of people's sovereignty. And the second one is that the power is not exercised directly by the people, but it is exercised, as the sentence I just read before, it is exercised by elections, by votes, and of course by specific bodies of power, the legislative, executive, and judicial bodies. So what is the first, well, let's say the first conclusion? The first conclusion is that our Constitution has the principle of representation, and with this principle of representation, you could conclude from this principle of representation that welfare organizations do not have a direct role within national legislation. So this is the first conclusion that everybody would draw from this principle of people's sovereignty. And on researching for this presentation, I surprisingly found a decision of the Federal Constitutional Court on this principle of people's sovereignty from the year, I think, 2017. And the Federal Constitutional Court said the people's sovereignty also contains a right to equal participation in political decision-making processes. So I thought, the first thing I thought, wow, maybe this decision might disapprove my first conclusion that our Constitution says there is no right to participation of welfare organizations, and I wanted to know more about this specific right to equal participation in political decision-making processes. I wanted to know what's the content of this right, because it's not explicitly named within this article, and I will come back to this point later. But before I want to talk about the rights of welfare organizations within decision-making processes, I would like to put the question: if the people themselves do not exercise the power of the three branches, so what about the deputies, the representatives that exercise the power? So you would find the answer to this question in Article 38, paragraph 1, sentence 2 Grundgesetz, and it says, the members of the German Bundestag shall be representatives of the whole people, not bound by orders or instructions, and responsible only to their conscience. So what is the meaning of this article at the background of our question? The participation of welfare organizations within political process. Well, first of all, we can derive from this article that our deputies have a special status. They are members of the German Bundestag. They are, as members of German Bundestag, holders of a mandate and not public servants or employees of the Bundestag, but they are holders of a mandate. And the interesting thing as to our question is that deputies, members of parliament, are committed to the whole people and not only to interest organizations or to their voters. So what would be the conclusion? If the deputies are obliged to represent all people, they do have to decide on many different matters within policy. And of course, deputies cannot be experts in all matters, but they need expertise from outside. So I thought this maybe is the first clue to the question why deputies need expertise from outside. They need input. They need input, especially, well, in the fields of social law. They do definitely need the input of welfare organizations in order to take decisions with respect to their special status. I now want to just briefly show you the legislative procedure and want to show you where practically this input of welfare organization takes place. Well, our Constitution has more or less two regulations, Article 76 and Article 77, which describe the legislative procedure on national level in Bundestag. But if you read these articles, we won't, but if you read these articles, you will see that these articles only have a rough idea on the procedure within the Deutscher Bundestag. You wouldn't find, for instance, a regulation saying that deputies need to hear welfare organizations or other interest organizations. But in fact, it takes place. This is the process, well, the process under the legislative procedure under the violet now I'm looking for the word. Huh? Error. You will find how it really takes place in practice. Before a bill is introduced by the federal government as introduced to German Parliament, of course, it needs to be written, and usually it's written in the federal ministries, and within this process in the federal ministries there are regularly hearings of interest organizations. And there is another hearing which takes place during the legislative procedure after the first reading in Parliament. The Bundestag would send a bill to the committees, and there the bill would be discussed, and interest organizations would be heard by the deputies within the committees. So there are two hearings taking place in this legislative procedure, but of course these two hearings are not subject to our Constitution. So, and this puts the question whether there is any right if it is not part of our Constitution. Lawyers would ask if there is a right to being participated in these legislative procedures. And now in the second part I would like to focus on the rights in political decision-making processes. And first of all I want to come back to this strange right to equal participation in political decision-making processes, which is derived from the people's sovereignty. There is actually just little information. You wouldn't find this right mentioned in Article 20 Grundgesetz, but you wouldn't find much literature on it either. You would find only 3 decisions of the Federal Constitutional Court. Only 3 decisions. The first decision was in the first decision, the Federal Constitutional Court only points out that Article 20, paragraph 1 and 2 gives citizens the right to equal participation in political decision-making processes. The Federal Constitutional Court only refers to a right without explaining what it really means. So you would have to look further, and I found two further decisions of the Federal Constitutional Court, but with very little information. In these two other decisions, the Federal Constitutional Court would say the right contains the claim of every citizen to be exposed only one public power that he can legitimize and influence. So this is the only information we have of this strange right to equal participation in political decision-making processes. And I would draw the conclusion that the Federal Constitutional Court did not mean a right to participation in political decision-making processes, but it meant that every citizen has a right to legitimize decisions of the three branches of power. So this right wouldn't help us with our question whether there is a right of welfare organizations to participate in political decision-making processes. The second idea I had was there is a similar right in our Constitution, which is the right of fair trial. Article 103, paragraph 1, Grundgesetz. And its wording is the courts, in the courts, everyone shall be entitled to a hearing in accordance with law. So what does that mean? This means that everyone has the right in court to be heard. And this means on the other side that courts need to consider arguments that accused persons, claimants or defendants address or utter within a process before court. So in this case we do have a right to participate, but it's not a right to participate in a legislative process, but in trial. In a court trial. So this won't help. And if you look at the other fundamental rights we have, we might think of freedom of speech. Of course, freedom of speech guarantees the freedom to express an opinion, also to welfare organizations. But on the other hand, freedom of speech would not guarantee a right of participation. Freedom of coalition or freedom of association guarantee the right to form interest organizations, to form an association, a welfare association, but it does not guarantee the right of participation. And finally, I found a fourth decision of the Federal Constitutional Court. And in this decision, the court had to decide on a case where a law was passed very quickly, and there was no real hearing within this legislative process. And the Federal Constitutional Court said generally it is left to the discretion of legislative bodies which associations and experts have their say in a hearing procedure. So what does that mean? This means that the legislative bodies have a range of options. They can decide whether to hear an association A or B, or just one, just A or just B. They have a wide range of options, and the legislative bodies have to balance all pros and cons and take finally a justified decision. But there is no right to participate in political decision-making processes. So, and this result drawn from our Constitution would be confirmed by having a look to the rules of procedure within ministries and rules of procedure within Deutscher Bundestag. And there are, I just want to point out this regulation, timing, scope and selection of associations shall remain at discretion of the federal ministry in charge. And in the Deutsche Bund, in the according rules of the Deutscher Bundestag, it said to provide information on a subject, a committee may hold, not must hold, but may hold public hearing of experts. So, if there is no right, but if it is just at the discretion of the legislative bodies, it is clear that that welfare organizations need good instruments to influence and to be heard within the political process. And I just want to briefly introduce 5 legal instruments that, to my opinion, play a certain role. And we can discuss these instruments later if you want to. First of all, the petition to Parliament, which is a fundamental right of our Constitution. Of course, a comment on a bill is a very popular instrument of welfare organizations in order to participate within political decision-making processes. Public relations, of course, is a very popular instrument. Appeal to authority is is not a very popular instrument, but in my opinion, it can be used as an instrument within political decision-making processes, as well as legal action to court. There are very good examples that, for instance, especially legal actions to court were quite successful in the end. So what are the legal and practical boundaries to these instruments? And you will find some legal boundaries in red and practical boundaries in orange. Legal boundaries are, of course, the barriers of fundamental right. You might know that except for the right of human dignity, all fundamental rights can be restricted by the government. And of course, the government does restrict not the government, but the Bundestag restricts fundamental rights every day. One restriction, for instance, is the lobbying register, which has been introduced a couple of years ago. And of course, the deputies' rights also put certain legal boundaries in political decision-making processes, because the welfare organizations do have to respect the freedom, the free mandate of the members of parliament. And what are, in my opinion, practical boundaries? Of course, financial resources of welfare organizations is a very important boundary to effectively influencing decision-making processes at national level. I should say expertise in lobbying is a practical boundary as well, because you need to know whom to address within the political decision-making process in order to succeed, in order to put your interest. And finally, a very important boundary in my view has much to do with the organizational settings. Of course, at national level, the associations, the Bundestag would only hear associations at national level. But if you want to, for instance, put a certain interest within the fields of social work to the government, you need the expertise of people working in the people working in the fields of social work. So the question really is, how is this expertise brought to the top of an organization and set to the deputies in parliament? I think that the organizational question, the organizational development, is one of the main practical boundaries, and which makes sometimes the participation in decision-making processes somewhat inefficient, because much expertise is lost during these organizational processes within the welfare organizations. So finally, what is my conclusion? Actually, we have a long and we have a good tradition of participating welfare organizations within the legal legislation at national level, but at the other levels as well. The EU level, the Länder, the federal, state level, and the community level. And there are, of course, statutory obligations of participating associations, where ministry and the Bundestag sort of is obliged is in a certain way obliged to participate associations, because the deputies need expertise from outside. On the other hand, there is a right to influence policy within certain barriers. But in the end, there's no right to be heard within these political processes. So this would be this would be the most important legal basis, which I think are important to understand how participation of welfare organizations in political decision-making processes in Germany work. Thank you very much for your attention.